So I'll be talking about principles of trial. Well, there are almost 20 principles which judiciary follows because these principles are important, and in order to ensure the free and fair administration of justice, this is necessary. So I will read out what are the principles and why these principles are important, and I will also provide an explanation along with that. That will be an additional note because you need to have the idea why such principle is being followed. Is it just followed in India, or is it followed all over the world, or is there any kind of differentiation in following of principles? So trial is what, and when does trial begin? What is the difference between investigation and trial? What is the meaning of inquiry? What is charges? What is FIR? What is Indian Evidence Act? So all these things will come in the process of talk. So I'll be starting with the first principle. The first principle is independence of judiciary. Well, what do I understand by that is independence of judiciary means this organ of the state is free from the control of executive and legislature, but there is an overlapping. Now, overlapping in what sense? Overlapping means that there are certain areas where executive and legislature do practice control over judiciary, but that doesn't compromise the independence. I will explain it how. Look, there is a system of appointment of judges through the system of collegium. And collegium is what? It's just a group of judges in which they decide and they nominate an advocate or an individual who is very well versed in judiciary or has the knowledge of judicial proceedings. He could be a jurist, he could be a well known lawyer, barrister, solicitor. So they decide, and after reaching onto a consensus, they recommend a name to the cabinet. Basically, the name goes to the Ministry of Law and Justice, and then it goes to the president. And after the signing of the document by the President of India, a judge is appointed. Now, there are certain criteria on the basis of which a judge is appointed. Now, a person who wants to get appointed as the judge of a high court, he needs to fulfill those criteria. Now, the one criteria is that at least a lawyer needs to have 10 years of practice, experience of 10 years of practice in a high court within the territory of India. Sometimes what happens that a name is recommended by the collegium directly from bar to the Supreme Court. So there have been few instances where such practices have been undertaken, but this is not common. This is done rarely. In the case of Justice Fali Nariman, Rohinton Nariman, where he was appointed the judge of the Supreme Court of India directly from bar, he had put in 34 years of practice. He had started his practice in 1980, then he did his LLM from Harvard Law University, then he came back and he started practicing under the supervision of his father, because his father was a very well known lawyer and he is still alive, he is practicing. So he had this advantage and he had this opportunity, so he used that opportunity and established himself as a very well known lawyer. So the main interest of his practice was arbitration law, because and now I will not talk about arbitration right here, because that is a completely a different area and needs a different session to discuss about that. But what I'm trying to say is that in the appointment of judges, executive only plays a very minor role, and that is that the appointment. But the selection of judges is done by the judiciary itself. There is no involvement of the executive and legislature in that. Maybe the final call is taken by the president, and certain credentials are checked whether that person is qualified to be appointed as judge or not. That is examined, and on the basis of that examination that is done by IB, Chief Justice of India has explained it elaborately, that how the process is initiated, that on the basis of the report that is submitted by the IB, the collegium system also undertakes that and thinks about that, because appointment of judges is not a very simple thing, it's a very complex thing, because it's going to impact the whole country. If it is at state level, obviously the state is going to get impacted. So very minor details are checked, because this is a very it's a very top notch appointment. This is not a low level appointment done by executive. President is the part of executive, but president is also the head of the state. Prime minister doesn't do that, because prime minister is the head of the government and the government changes but the state remains. Though the president is elected indirectly, but that doesn't mean that president is just a nominal head. Though he is a nominal head, but every action taken by the government of India is done on the name of President of India. Every executive order that is passed is finally given accent by the president. So independence of judiciary and court, that means, because it is also a part of basis structure doctrine which is nowhere defined in the constitution, because it is embedded in the articles of the constitution, and that was what YV Chandrachud had explained, that these doctrines have not been defined, but it is upon the judiciary to come up with such doctrines as the time demands. So now the second principle is independence of the judges. Now judges are supposed to be free, impartial, and from my perspective should be remain uninfluenced by the outer forces. Now outer forces include a lot of things which I will not, that could also be executive, legislature, because executive and legislature, they both are overlapped, because the ministers also sit as the member of parliament in the parliament. So magistrates are generally found in the civil court. So the third principle is principle of natural justice. Now what does natural justice mean? It means that nobody can be tried without being heard. Now suppose if there is an allegation over me that I have committed certain crime and I am responsible, then I should be heard. I should be given a fair chance to put forward my defense, my arguments, and nobody can stop me that from doing that. I am eligible. This is deeply enrooted in the Constitution of India, and that's how the trials are conducted. I cannot be tried without being heard, and that is why whenever a proceeding is initiated, the accused is called upon to be present physically. If he cannot be present physically, certain arrangements are done so that he may be present, if not physically but virtually. Now, there have been technological advancements, no doubt. So, via live streaming, Zoom, YouTube, there are n number of options available. So, by using that, one can do that. But the trial should be conducted in open court. If a trial is conducted in a closed room, then it violates the principles of trial. Now, the fourth is reasons must be stated before the accused as to why he or she is being prosecuted. Now, if there is an allegation, or if I have been arrested by the police, it is the duty of the police to present the accused before a magistrate within 24 hours, excluding the time of traveling. And there is right to representation. If I cannot afford a lawyer, it is the duty of the state to provide a lawyer to me, because I should be given fair chance to protect myself from the allegations that have been put against me. So a trial would be illegal if the reasons have not been stated. I mean, on what basis a trial would be conducted if the reasons are not clearly stated? I mean, on what basis the judge will decide that this person has committed a crime or not? Because the objective of a trial should be clearly mentioned, and this should be clear in the mind of the judge or a magistrate, that on what basis he will deliver or administer the judgment, because he administers justice to the people by his judgments. So this is a very difficult task in front of a judge or a magistrate, because the judgment is going to impact the life of both the parties, be it petitioner or be it respondent, it doesn't matter.